Appeals of Tennessee is now in session.
Thank you, Madam Clerk. This is the November session of the Court of Criminal Appeals here in Nashville, Tennessee. My name is Robert Wiedemeyer. My colleagues on this panel today are Judge Robert Holloway from Columbia and Judge Ross Dyer from Memphis. We are operating on Zoom, and we're grateful to the AOC and Nick Morgan for assisting us with the technology, and we're also grateful to the clerk's office here, Mr. Hivner, and of course Miss Lindsay for the technology and the assistance in getting these cases heard despite the pandemic. And we're all looking forward very much to getting back into the courtroom as soon as possible. We will conduct the proceedings today just as if we were in the courtroom. That means each side has 20 minutes. We also have read your briefs, and so we're prepared to that extent. We have not been assigned the records, but if you want to tailor your arguments based on the fact that we have read your briefs, feel free to do so. I understand the appellant will have 3 minutes, requesting 3 minutes for rebuttal, so I'll try to help you keep up with your time. I think those are all the preliminaries. Madam Clerk, will you please call the next case?
State of Tennessee versus Jerome Andre McClinton.
All right. Let's see. Mr. Wilson, you represent the appellant?
Yes, Your Honor, I do. And may it please the court. Good morning. Brian Wilson with the Appellate Division of the Public Defenders Conference here on behalf of Jerome Andre McClinton. If you please the court, may I please officially reserve 3 minutes for rebuttal?
Certainly.
Thank you, Your Honor. We are here solely on a sentencing matter out of Putnam County today. In particular, we ask this court to reverse a denial of probation regarding a 10-year sentence that Mr. McClinton was ordered to serve with the Tennessee Department of Correction. The trial court ordered this sentence without fully considering Mr. McClinton's potential for rehabilitation or his amenability to correction, which we argue is an erroneous application of the law and abuse of discretion. We also argue that this ruling came despite proof and two defense witnesses that showed Mr. McClinton's willingness to improve his life, to seek drug treatment, to confront his addiction that had gotten him into this position in the first place. We argue that that is an erroneous assessment of the proof and it also warrants reversal. In essence, Your Honor, this case comes largely centered around this potential for rehabilitation that Mr. McClinton has, and we argue that the trial court did not fully consider at a sentencing hearing. For a factual background, Mr. McClinton pleaded guilty to possession of methamphetamine with intent to solely deliver in February of 2020. There was a plea agreement here, but the manner of service for this 10-year sentence was reserved to be determined at a later hearing. At that sentencing hearing, Mr. McClinton called two witnesses to testify in his support, who both argued that Mr. McClinton had changed in recent years and was willing and able to get treatment to deal with his addiction and to reenter society. The first witness was a woman named Linda Barker, who had not only heard Mr. McClinton's testimony, but had seen it in action in a way. Her grandson had been incarcerated with Mr. McClinton, and through Mr. McClinton's counsel, this individual, Jesse Cole Martin, had reformed. He had through just counsel and discussions about faith, decided to receive treatment and was released from prison and got steady employment. Ms. Barker, the witness in this case, stated that that wouldn't have happened but for Mr. McClinton. She said that she had stayed in contact with Mr. McClinton that after this, and that he had changed his attitude while he was in prison and would take full advantage of any opportunity for rehabilitation that he could receive. In addition, Mr. McClinton received support from Ms. Nikki Payne, who had helped Mr. McClinton through her past position as a recovery counselor. Ms. Payne had interviewed dozens of inmates over the years to gauge their desire for recovery and their willingness to do so. And she believed that Mr. McClinton was genuine in his desire for treatment. She had helped him try to set up entry into recovery programs that he had gauged interest in, and was willing to help him complete recovery program and re-enter life if he had received an alternative sentence. Nevertheless, the trial court ordered Mr. McClinton to serve his sentence in state custody, in addition to consecutive to additional convictions that already existed. The trial court's analysis for Mr. McClinton's potential for rehabilitation or treatment was largely limited to acknowledging the testimony of Ms. Barker and Ms. Payne and deeming that testimony credible. This analysis did not directly address whether Mr. McClinton had the potential for rehabilitation or was even amenable to correction, particularly at that time, given the nature of the proof. Instead, the trial court discussed Mr. McClinton's criminal history, discussed prior violations of probation, and ordered him to serve his sentence. Your Honors, we argue that the trial court's analysis did not fully align with the proof presented at the sentencing hearing and did not include the necessary analysis under case law and state statute. Because of that, we argue that this sentence should not stand. First, the trial court ignored the proof that Mr. McClinton had shown that supported his potential for rehabilitation, even as the trial court acknowledged that the testimony was credible. This court has said in State v. Keene that analysis of potential to rehabilitation is fundamental to the consideration of a sentence. Nevertheless, there was no real analysis of this potential beyond an acknowledgement of the proof in the record. There was no consideration about why or whether Mr. McClinton had that potential, or why, in essence, why the trial court felt that potential did not matter in light of other factors.
Mr. Wilson, let me ask you a question. Didn't the trial court find that the defendant had a long history of criminal offenses?
The trial court did make that finding, Your Honor. Many of those.
And didn't the trial court find that other measures, less restrictive measures, had been unsuccessfully applied?
Yes, Your Honor. The trial court did find that.
With those findings, why are you saying that the trial court did not articulate reasons for denying rehabilitation?
Well, Your Honor, we argue that there are other factors at play here beyond the three factors: the criminal history, the seriousness of the offense, the probation or the other efforts, less restrictive measures taken. Again, we argue that this court has said that other analyses are fundamental in issuing an alternative sentence. We also argue that in State v. Trent, that there are other factors that are encouraged, that trial courts are encouraged to consider or to make when issuing or denying an alternative sentence, such as probation. In addition,
let me follow up on Judge Holloway's question. Can I not find that Judge Wiedemeyer and Judge Holloway and yourself are all credible, but then still, based on the fact that this defendant has had numerous chances on probation and numerous probation violations, isn't enough to carry the day? The fact that y'all are credible is still not enough to carry the day, that he's had his chances at probation and he continues to fail. And though he may have a good heart and may want to try, it doesn't work.
Your Honor, that you could certainly make that finding. What we argue is that there wasn't the connection. There was a statement. There was a statement of almost just a prima facie statement about potential for rehabilitation, but it was not connected to. There was no explanation of why that didn't matter. It was simply the trial court's ruling was much more of here's the criminal history, here are the factors, here's the.
Isn't that what he's saying implicitly? Isn't that what he's saying? Is here's what I have to look at. One of those things is failed attempts on probation, failed to seek rehabilitation before, or failed attempts at rehabilitation, whatever those things are that he said. Where in the law does it say he has to say some magic words that all of this is why I'm discounting the credibility determination I made. I don't know that that's there, is it? He just has to consider the factors and reach a conclusion.
Well, Your Honor, there are certainly no magic words that are needed under State v. Trent. However, I believe that there is also I'm trying to find the exact language here. Trial courts must articulate fully and coherently the various aspects of their decision as required by statute and case law. And under that standard under Trent, we argue that did not happen here, that there wasn't the full articulation as to why. And while a finding could be implicit, that there has to be still some sort of articulation as to why a decision was made.
All right, one more question, then I'll stop. But okay, let's say he didn't articulate it well enough. Does the record preponderate against what the decision he made? How do we reverse it?
Your Honor, the proof in this case overwhelmingly indicated that, at least from the testimony in the record, that Mr. McClinton had a capacity for change in a support system that was willing to help him complete treatment and re-engage with society. We argue, based on the proof in the record itself, that this decision is not exactly aligned with it, and would warrant reversal. In essence, the trial court's analysis again did revolve around Mr. McClinton's criminal history, which, in essence, while there are several convictions, the vast majority of them are traffic violations, shoplifting, simple possession charges. There were also several dismissals over the years, and we argue that, just based on the record in this case, that more was needed under the purposes and principles of sentencing to deny probation in this matter. In sum, Your Honors, this case involves a defendant who is ready for treatment and has the support to complete it and the willingness to re-engage with society. The trial court never fully considered this, whether in a potential for rehabilitation or amenability to correction, which is a fundamental analysis in considering whether to grant an alternative sentence or deny probation. We argue this court abused its discretion, or the trial court, that the trial court abused its discretion in ordering Mr. McClinton to serve, and that his sentence should not stand. We ask this trial court to reverse the trial court's judgment and remand for a new sentencing hearing, or if the record is sufficient, to conduct an over review and order Mr. McClinton to serve the remainder of his sentence on probation or in some sort of split sentence capacity. If there are no further questions before this court, I'll reserve the remainder of my time for rebuttal.
All right, thank you, Mr. Wilson. General Douglas, are you ready to be heard?
Yes, Your Honor. May it please the court. Good morning, Davey Douglas on behalf of the state. And we would ask this court to affirm the trial court's denial of probation. The trial court specifically considered the defendant's potential for rehabilitation, and it did not abuse its discretion by ordering a sentence of confinement. A trial court's decision to grant or deny probation will not be invalidated unless the court wholly departed from the relevant statutory considerations. Here, the trial court identified those considerations, specifically the defendant's potential for rehabilitation. It identified the factor and noted that we had heard proof of that today from witnesses Nikki Payne and Linda Barker, and it specifically credited the testimony of those witnesses. But having found some evidence of the defendant's potential for rehabilitation, it was not then required to automatically give the defendant probation. Instead, it was able to weigh the proof of this potential against the evidence that would cut against the defendant's potential for rehabilitation. The court specifically considered the defendant's strong R assessment, which showed that he had a high probability of reoffending with drugs. The court also noted the defendant's prior criminal history, which included numerous convictions, and that the defendant had a history of drug selling and drug dealing. And having considered all of that proof, the court was then entitled to weigh it, which it did, and it found that there was some evidence of the defendant's potential for rehabilitation, but that there were other factors that supported its sentence of confinement. The court then went on to, for example, find 3 factors that cut against a sentence of confinement. The court first found that confinement was necessary to protect society from a defendant with a long criminal history. The defendant's pre-sentence report showed that he had numerous convictions for felonies and misdemeanors in multiple different states, and that these offenses included convictions for drug crimes. And the next factor the court found was that confinement was necessary to avoid depreciating the seriousness of the offense. And the court did not just rely on the defendant's criminal history to find this factor, but it specifically found that the defendant was charged with one of the most serious offenses that a defendant could be charged with in Tennessee. And then the third factor that the court found was that other means other than incarceration had been unsuccessfully applied to the defendant. And his pre-sentence report showed that on 3 prior occasions he had received probation and that he had violated his probation. So the trial court properly considered all of the proof before it at the sentencing hearing, including the proof of the defendant's potential for rehabilitation. And based on the weight of the evidence, the trial court did not abuse its discretion in finding that a sentence of confinement was warranted. The record fully supports the trial court's determinations, and it did not abuse its discretion by ordering the defendant to serve his sentence in confinement. And if there are no questions, we would ask this court to affirm the judgment of the trial court.
Thank you, General. Mr. Wilson, rebuttal.
Thank you, Your Honor. I'll make 3 quick points. The first, regarding the strong R evaluation, at the sentencing hearing, TDOC conceded that such a finding was spoke more of whether treatment was necessary and did not automatically equate to a likelihood to reoffend, just for being on a high drug classification. In addition, while the trial court found that confinement was necessary based on the seriousness of the offense, we would argue, and we did in our reply brief, that the trial court's conclusion didn't entirely align with how this court has held in State v. Bottoms that factor to apply. This court held that the factor doesn't apply when the offense was an act that was isolated, that didn't harm people other than the defendant, and when law enforcement was called quickly after an offense occurred. Something similar happened here. There was a sting operation on a drug charge. No one was seriously at risk. There was no risk of harm here. And we argue that based on that similarity, that factor shouldn't apply. More broadly, Your Honors, we argue that while there was an acknowledgement of the evidence for potential rehabilitation, and there was a reading of these factors and an explanation of the various other factors in this case, there was no specific analysis needed to connect it all, or that was needed to connect it all together to explain explicitly how all of these factors weighed against each other and what the correct outcome would be. Without that type of analysis, we argue that this sentence fails to meet the purposes and principles of sentencing and should not stand. With that, Your Honor, again, we ask this court to reverse the sentence and either remand for new hearing or conduct a de novo review. If there are further questions, thank you, Your Honors.
All right. Thank you, Mr. Wilson. Both attorneys have presented excellent arguments before this court today. We appreciate that, and as well as the excellent briefs that each of you submitted. And we'll take this case under advisement. I think that concludes this case.
Mr. Presiding Judge, can I ask a question, Mr. Presiding Judge?
Of course. Go right ahead.
Mr. Douglas, I wanted to wait till the argument was over with. Mr. Douglas, is Ms. Smith no longer with the AG's office? I see her name on several briefs, but not on the docket.
That's correct, Your Honor. She recently moved.
Okay.
She left the state.
Okay. Thank you.
Mr. Wilson, were you appointed on this case? Are you with the state public defender?
Yes, Your Honor. I'm part of the appellate division of the Public Defenders Conference.
Yeah, your office does really good work, and we appreciate it. I just wanted you to know that. Your office is in Franklin, is that right? With several attorneys down there, I assume.
That's correct, Your Honor.
All right. All right. Well, keep up the good work. Thank you very much. Madam Clerk, we'll be in recess.
This Honorable Court of Criminal Appeals is in recess until 1 p.m.